The following information, material, and content is covered under fair use. This is for training and educational purposes only, for teaching and commenting in a classroom setting. Again, this is for training and educational purposes only. This does not constitute tax advice, legal advice, nor financial advice. If you need any applicable advice, please seek competent counsel. Do your own due diligence, regardless of who presents the information. All rights, titles, and actions or interests reserved ab initio without prejudice. Hey everyone, it's B with To Be Fruitful Training Group. All praises to the Most High. And today we're covering the as requested Cestui Que Vie Part 3. And herein we'll be covering all the acts and statutes, how it's applicable here in America, and what one might have to do in order to reclaim their estate. So as far as this article goes, we have Cestui Que Vie published by Henry Fisher as part of case text by Thomson Reuters. And again, this is for fair use, for teaching and commenting in a classroom setting. Here we have rights, suspension, and corruption, Article 100, Cestui Que Vie Trust, Canon 2036. Cestui Que Vie Trust, also known by several other pseudonyms such as, quote, term for life or years, or pure outre vie, or fide commissary trust, or foreign situs trust, or secret trust, is a pseudo form of trust first formed in 16th century under Henry VIII of England on one or more presumptions, including but not limited to one or more persons. What are those three persons? John Doe, John H. Doe, and John Henry Doe. And you have the variations in capitis diminutio minima, as seen above, and capitis diminutio maxima, as seen below. Presumed wards, infants, idiots, lost or abandoned at sea, and therefore assumed or presumed dead after 7 years. Additional presumptions by which such a trust may be legally formed were added in later statutes to include bankruptcy, incapacity, mortgages, and private companies. Canon 2037. In terms of the evidential history of the formation of Cestui Que Vie trusts, the first Cestui Que Vie trusts formed were through an act of Henry VIII of England in 1540. The statutes, made at Westminster in the 32nd year of Henry VIII, in the year 1540, entitled The Act of Wills, Wards, and Primary Seasons, whereby a man may devise two parts of his land. The reasoning or the cause is shown here in italics. What we have here states that all and every person and persons having or which hereafter shall have any manors, lands, tenements, or hereditaments, holden in soccage, or of the nature of soccage tenure, and not having any manors, lands, tenements, or hereditaments, holden of the king, their sovereign lord, by knight's service, by soccage tenure in chief, or of the nature of soccage tenure in chief, nor of any other person or persons by knight's service, from the 20th day of July in the year 1540, shall have full and free liberty, power and authority to give, dispose, will, and devise, as well by his last will and testament in writing, or otherwise, by any act or acts lawfully executed in his life, all his said manors, lands, tenements, or hereditaments, or any of them, at his free will and pleasure, any law, statute, or other thing heretofore had, made, or used to the contrary, notwithstanding. And later, wholly corrupted, whereby the poor people of England, after having all their homes, goods, and wealth seized in 1535, And here, 1535, under Henry VIII, all monasteries given to the king which have not lands above 200 pounds by the year. And thereupon, most humbly desire the king's highness that it may be enacted by authority of this present parliament, that his majesty shall have and enjoy to him and his heirs forever, all and singular such monasteries, priories, and other religious houses of monks, canons, and nuns, of what kinds of diversities of habits, rules, or order soever they be called or named, which have not in lands, tenements, rents, tithes, portions, and other hereditaments above the clear yearly value of 200 pounds. Under the guise of small religious estates under 200 pounds, were granted the welfare or commonwealth benefit of a cestui use, or simply an estate, with which to live, to work, and to bequeath via a written will. And in 1666, Westminster and the ruling classes passed the infamous Proof of Life Act, also called the Cestui Que Vie Act, whereby the poor and disenfranchised that had not proven to Westminster and the courts they were alive were henceforth to be declared dead in law, and therefore lost, abandoned, and their property to be managed in their absence. This supremely morally repugnant act, which remains in force today, is the birth of Mundi and infamous occult rituals of the British courts in the wearing of black robes and other paraphernalia in honoring the dead, quote-unquote. The Cestui Que Vie Act, 1666. An act for redress of inconveniencies by want of proof of the deceases of persons beyond the seas or absenting themselves, upon whose lives estates so depend, or do depend. Recital that Cestui Que Vies have gone beyond the sea, and that reversioners cannot find out whether they are alive or dead. Whereas diverse lords of manors and others have granted estates by lease for one or more life or lives, or else for years determinable upon one or more life or lives. And it hath often happened that such person or persons for whose life or lives such estates have been granted have gone beyond the seas or so absented themselves for many years, that the lessors or reversioners cannot find out whether such person or persons be alive or dead, by reason whereof such lessors and reversioners have been held out of possession of their tenements for many years after all the lives upon which such estates depend are dead, in regard that the lessors and reversioners, when they have brought actions for the recovery of their tenements, have been put upon it to prove the death of their tenants, when it is almost impossible for them to discover the same, for remedy of which mischief so frequently happening to such lesser or reversioners. Cestui Que Vie remaining beyond sea for 7 years together, and no proof of their lives, judge in action to direct a verdict as though Cestui Que Vie were dead. If such person or persons, for whose life or lives such estates have been or shall be granted as aforesaid, shall remain beyond the seas or elsewhere absent themselves in this realm, by the space of 7 years together, and no sufficient and evident proof be made of the lives of such person or persons respectively, in any action commenced for recovery of such tenements by the lessors or reversioners, in every such case, the person or persons upon whose life or lives such estate depended shall be accounted as naturally dead, and in every action brought for the recovery of the said tenements by the lessors or reversioners, their heirs or assigns, the judges before whom such action shall be brought shall direct the jury to give their verdict, as if the person so remaining beyond the seas or otherwise absenting himself were dead. And of course, with every inequity, there must be a relief or a remedy, especially with legislation or enactments, to which Part 4 is given. If the supposed dead man prove to be alive, then the title is revested. Action for mean profits with interest, provided always that if any person or persons times 3 shall be evicted out of any lands or tenements by virtue of this act, and afterwards, if such person or persons upon whose life or lives such estate or estates depend shall return again from beyond the seas, or shall on proof and any action to be brought for recovery of the same, to be appear to be living, and then the 2 is times 3, there's 3 persons, or to have been living at the time of eviction, that then and from thenceforth the tenant or lessee who was outed out of the same, his or their executors, administrators, or assigns, shall or may re-enter, repossess, have, hold, and enjoy the said lands or tenements in his or their former estate, for and during the life or lives or so long term as the said person or persons upon whose life or lives the said estate or estates depend shall be living. Notice how it's spelled. And also shall upon action or actions to be brought by him or them against the lessors, reversioners, or tenants in possession, the administrators de suntort, or other persons respectively, which since the time of the said eviction received the profits of the said lands or tenements, recover for damages the full profits of the said lands or tenements respectively, with lawful interest, not legal, lawful interest, for and from the time that he or they were outed of the said lands or tenements, and kept or held out of the same by the said lessors, reversioners, tenants, or other persons who after the eviction received the profits of the said lands or tenements, or any of them respectively, as well in the case when the said person or persons upon whose life or lives such estate or estates did depend are or shall be dead at the time of bringing of the said action or actions, as if the said person or persons were then living. In 1707, Westminster, under Queen Anne, extended the provisions of proof of life and Cestui Que Vie, extending the use of such structures ultimately for corporate and other franchise purposes. This wicked, profane, and completely sacrilegious act, in direct defiance to all forms of Christian morals and rule of law, has remained a cornerstone of global banking and financial control to the 21st century. And out of the Cestui Que Vie Act, 1707, an act for the more effectual discovery of the death of persons pretended to be alive, to the prejudice of those who claim estates after their deaths. I wonder if this is where they got UCC 1-308 without prejudice. Continuing. So we have the usual language. So it states here, Part 3, if it appear afterwards in any action to be brought that such tenant for life was alive at the time of the order made, then he or she may re-enter and have action for rent, etc. Provided always that if it shall afterwards appear upon proof in any action to be brought that such infant, married woman, or other person for whose life any such estate is holden were alive at the time of such order made, that then it shall be lawful for such infant, married woman, guardian, or trustee, or other person having any estate or interest determinable upon such life, to re-enter upon the said lands, tenements, or hereditaments, and for such infant, married woman, or other person having any estate or interest determinable upon such life, their executors, administrators, or assigns, to maintain an action against those who since the said order received the profits of such lands, tenements, or hereditaments, or their executors or administrators, and therein to recover full damages for the profits of the same, received from the time that such infant married woman or other person having any estate or interest determinable upon such life were ousted of the possession of such lands, tenements, or hereditaments. It states here also, guardians, trustees, etc., holding over without consent of remainder men, etc., deemed trespassers, damages. So, and every person who as guardian or trustee for any infant, and every husband seized in right of his wife only, and every other person having any estate determinable upon any life or lives, who after the determination of such particular estates or interests, without the express consent of him, her, or them, who are or shall be next and immediately entitled upon and after the determination of such particular estates or interests, shall hold over and continue in possession of any manors, messuages, lands, tenements, or hereditaments, shall be and are hereby adjudged to be trespassers. In 1796, King George III, through this statute, applied duty to estates pure outre vie for the first time. And the Stamp Act, March 22nd, 1765, was the original act that was referenced. It was later applied from regular estates to the Cestui Que Vie accounts in 1796. And it states here, for every skin or piece of vellum or parchment, of sheet of piece of paper, on which shall be engrossed, written, or printed any probate of will, letters of administration, or of guardianship for any estate, above the value of 20 pounds sterling money, within the British colonies and plantations upon the continent of America, the islands belonging thereto, and the Bermuda and Bahama Islands, a stamp duty of 5 shillings. So, in looking to ChatGPT, what is the estimate of 5 shillings from 1765 to dollars today? It's a rough estimate, but what it gives, approximately that much. In 1837, under the statute of Queen Victoria and the amendments to the nature of wills, that if a person under an estate pure outre vie, Cestui Que Vie, did not make a proper will, then such property would be granted to the executors and administrators. In the first year of the rule of Victoria, an act for the amendment of the laws with respect to wills, 3rd July 1837. 3. And be it further enacted, that it shall be lawful for every person to devise, bequeath, or dispose of, by his will, executed in manner hereinafter required, all real estate and all personal estate, which he shall be entitled to, either at law or in equity, at the time of his death, and which, if not so devised, bequeathed, or disposed of, would devolve upon the heir at law, or customary heir of him, or if he became entitled by descent of his ancestor, or upon his executor or administrator. This is especially key to note. If one is considered chattel property, then one has no right of ownership with regards to certain things that the king was reserving. So naturally, it devolved upon the executor and administrator in many cases. In terms of the evidential history of the operation and any form of relief or remedy associated with Cestui Que Vie trusts, taking into account all statutes referencing Cestui Que Vie prior to 1540, are a deliberate fraud and proof of the illegitimacy of Westminster statutes. The first act, outlining Cestui Que Vie Trust, is deliberately hidden under the claimed statutes of the reign of King Richard III in 1483, whereby the act, still in force, states that all conveyances and transfers and use of property is good, even though a purchaser may be unaware it is effectively under Cestui Que use, subject to a Cestui Que Vie Trust. The act also gives a vague and challenged path of relief that if one is of complete mind, not an infant, and not under financial duress, then any property under Cestui Que Vie Trusts is rightfully theirs for use. The statutes at large, etc. In the first year of Richard III, statutes made at Westminster in the first year of the reign of King Richard III, and in the year 1483. Entitled, All Acts made by or against Cestui Que use shall be good against him, his heirs, and fiefs and trusts. Forasmuch by privy and unknown fiefments. Here, fiefments is a type of transfer or conveyance of property. Great unsurety, trouble, costs, and grievous vexations daily grow among the king's subjects, insomuch that no man that buyeth any lands, tenements, rents, services, or other hereditaments, nor women that have jointures or dowers in any lands, tenements, or other hereditaments, nor men's last wills to be performed, nor leases for term of life or of years, nor annuities granted to any person or persons for their services for term of their lives, or otherwise be in perfect surety, nor without great trouble and doubt of the same, because of the said privy and unknown fiefments, for remedy whereof be it ordained, established, and enacted by the advice of the Lords spiritual and temporal, and by the Commons in this present Parliament assembled, and by the authority of the same, that every estate, fiefment, gift, release, grant, leases, and confirmations of lands, tenements, rents, services, or hereditaments, made or had, or hereafter to be made or had, by any person or persons, being of full age, of whole mind, at large, and not in duress, to any person or persons, and all recoveries and executions had or made, shall be good and effectual to him, to whom it is so made, had or given, and to all other to his use, against the seller, fioffer, donor, or grantor thereof, and against the sellers, fieffers, donors, or grantors, his or their heirs, claiming the same only as heir or heirs to the same sellers, fieffers, donors, or grantors, and every of them, and against all other having claiming any title or interest in the same, only to the use of the same seller, fieffer, donor, or grantor, sellers, fieffers, donors, or grantors, or his or their said heirs at the time of the bargain, sale, covenant, gift, or grant made, saving to every person or persons such right, title, action, or interest, by reason of gift in tail, just seeming like fee tail, thereof, made, as they ought to have had, if this act had not been made. The second act, outlining Cestui Que Vie Trusts, is deliberately hidden under the reign of Henry VII in 1488. By this statute, permitted lords to render any attempt by a people classed as, quote, wards, to demonstrate their freedom useless, and that such lords may use writs and other devices to, quote, force such people back to being compliant, quote, wards, poor slaves. The only remedy under this act was if a ward demonstrated the waste of the lord as to the property and energy seized from the poor, ignorant white slaves. And by Henry VIII, the charges and benefit of the heir of Cestui Que Use. Item, whereby in a statute made at Marlbridge it was ordained that when tenants made fee-offments in fraud to make the lords of the fee to lose their wards, the lords should have writs to recover their wards against such fee-offees, as in said statute, among other things, appeareth more plainly at large. And out of Isaiah chapter 10, woe unto them that decree unrighteous decrees, and that right grievousness which they have prescribed, to turn aside the needy from judgment, and to take away the right from the poor of my people, that widows may be their prey, and that they may rob the fatherless. And what will ye do in the day of visitation, and in the desolation which shall come from far? To whom will ye flee for help, and where will ye leave your glory? Without me they shall bow down under the prisoners, and they shall fall under the slain. For all this his anger is not turned away, but his hand is stretched out still. The third act, outlining the operation of Cestui Que Vie, only hidden this time as a state per autra vie, was in 1741 under the statute, whereby one who was knowledgeable of the Cestui Que Vie slavery system could, between the ages of 18 to 20, seek to recover such property under Cestui Que Vie and cease to be a slave. However, the same act made law that after 20 years the remedy for such recovery was no longer available, despite the fact that the existence of the Cestui Que Vie Trust is denied, and Westminster and banks are sworn to lie, obstruct, hide, at all costs, the existence of the foundations of global banking slavery. 1741. An act to amend the law concerning common recoveries, and to explain and amend an act made in the 29th year of the reign of King Charles II, instituted an act for prevention of frauds and perjuries, so far as the same relates to estates per autra vie. Part 5. And whereas it has frequently happened that the deeds for making the tenant to the writs of entry, or other writs for suffering common recoveries, have been lost, or that the fines or deeds making the tenants to the said writs have not been levied or executed till after the judgment given in such recoveries, and the writ of season awarded, by reason whereof great doubts have arisen, whether such recoveries, for want of proper tenants to the writs, are good and effectual in law. To prevent such doubts for the future, and in order to render common recoveries for more certain and effectual, be it enacted by the authority foresaid, that every common recovery already suffered, or hereinafter to be suffered, shall, after the expiration of 20 years from the time of suffering thereof, be deemed good and valid to all intents and purposes, if it appears upon the face of such recovery that there was a tenant to the writ, and if the persons joining in such recovery had sufficient estate and power to suffer the same, notwithstanding the deed or deeds for making the tenant to such a writ should be lost or not appear. Whereas aequitas volt spoliatos vel deceptos vel lapsos ante omnia restitui. Equity wishes the spoiled, the deceived, and ruined above all things to have restitution. Equity regards as done what ought to have been done as a maxim of equity. Commercium jure gentium commune esse e debet, et non in monopolium et privatum paucorum quaestum convertendum. Commerce by the law of nations ought to be common, and not to be converted into a monopoly and the private gain of a few. So, seeing as equity regards as done what ought to have been done, those certain things that limit recoveries beyond 20 years cannot be held as valid. Either way, there is still an alternative remedy according to the prior acts. In terms of essential elements concerning Cestui Que Vie Trusts, a Cestui Que Vie Trust may only exist for 70 years, being the traditional accepted life expectancy of the estate, and a beneficiary under estate may either be a beneficiary or a Cestui Que Vie Trust. When a beneficiary loses direct benefit of any property of the higher estate placed in Cestui Que Vie Trust on their behalf, they do not own the Cestui Que Vie Trust and are only the beneficiary of what the trustees of the Cestui Que Vie Trust choose to provide them. And the original purpose and function of a Cestui Que Vie Trust was to form a temporary estate for the benefit of another because some event, state of affairs, or condition prevented them from claiming their status as living, competent, and present before a competent authority. Therefore, any claims, history, statutes, or arguments that deviate in terms of the origin and function of a Cestui Que Vie Trust, as pronounced by these canons, is false and automatically null and void. The trust corpus, created by Cestui Que Vie, is also known as the estate, from two Latin words, e and statuo, literally meaning by virtue of decree, statute, or judgment. However, as the estate is held in a temporary, not permanent trust, the corporate person, as beneficiary, is entitled only to equitable title and the use of the property, rather than legal title and therefore ownership of the property. Only the corporation, also known as body corporate, estate, and trust corpus of a Cestui Que Vie Trust possesses valid legal personality. As far as the Roman canons that assert these things, I'll let you read them for yourself. With regards to the contrary argument, whereby it is stated that these things are not applicable to America and its territories, we look to these principal authorities. And Hamilton versus Eaton, this is U.S. Circuit Court, 1796. Besides, the Treaty of 1783 was declared by an Act of Assembly of this state, passed in 1787, to be law in this state, and this state, by adopting the Constitution of the United States in 1789, declared the treaty to be the supreme law of the land. So, out of the Treaty of Paris, signed 1783, we look to Article 5. It is agreed that Congress shall earnestly recommend it to the legislatures of the respective states to provide for the restitution of all estates, rights, and properties which have been confiscated belonging to real British subjects, and also of the estates, rights, and properties of persons resident in districts in the possession of His Majesty's arms, and who have not borne arms against the said United States, and that persons of any other description shall have free liberty to go to any part or parts of any of the 13 United States, and therein to remain 12 months unmolested in their endeavors to obtain the restitution of such of their estates, rights, and properties as may have been confiscated, and that Congress shall also earnestly recommend to the several states a reconsideration and revision of all acts or laws regarding the premises, so as to render the said laws or acts perfectly consistent not only with justice and equity, but with the spirit of conciliation, which on the return of the blessings of peace should universally prevail. And that Congress shall also earnestly recommend to the several states that the estates, rights, and properties of such last mentioned persons shall be restored to them, they refunding to any persons who may be now in possession the bona fide price, where any has been given, which such persons may have paid on purchasing any of the said lands, rights, or properties since the confiscation. And it is agreed that all persons who have any interest in confiscated lands, either by debts, marriage settlements, or otherwise, shall meet with no lawful impediment in the prosecution of their just rights. Another authority, Hart versus Burnett, 15 California, 530, 1860. This case further confirmed that British common law, including principles governing trusts and estates, remain valid and enforceable in American courts, which is this case. Then there's Clearfield Trust Company et al. Versus United States, number 490, argued February 5th, 1943, decided March 1st, 1943. The case ruled that when the U.S. government engages in commercial activities, it is subject to the same laws and liabilities as any private corporation. Clearfield Trust Company versus U.S. Quote, "The United States does business on business terms. It is not accepted from the general rules governing the rights and duties of drawees, quote, by the largeness of its dealings and its having to employ agents to do what, if done by a principal in person, would leave no room for doubt," end quote. And Title 28, United States Code 3002, 15, A, B, and C. The United States means A, a federal corporation, B, an agency, department, commission, board, or other entity of the United States, or C, an instrumentality of the United States. As stated in a prior video, capital letter words and names are broken mirrors. The GPO Style Manual in Religious Terms 3.35 states that words denoting Satan are all capitalized, whereas quando diversi considerantur actus ad aliquem statum perficiendum plus respicit lex actum originalum. When two different acts are required to the formation of an estate, the law chiefly regards the original act. Given these authorities, I assert that statutes made at Westminster in the year of 1483 with King Richard III, the Cestui Que Vie Acts 1540, 1666, and 1707, are applicable here within America and within the United States. So then, how would you go about establishing and correcting this status or reclaiming the minor estate? Well, for one, we've already covered what capital letter names mean. So that's according to the GPO Style Manual. So as far as correcting the name, it's termed a name correction, although it's done by process of court-ordered name change. And there's plenty of authorities that state you can change your name for any lawful reason. This is just one example showing the difference. Which is substantiated by the Born Alive Infant Protection Act, which is codified as 1 United States Code, subsection 8. States here, in general, Chapter 1 of Title 1, United States Code, is amended by adding at the end of the following. Subsection 8, person, human being, child, and individual, as including born alive infant. In determining the meaning of any act of Congress, or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the words person, human being, child, and individual shall include every infant member of the species Homo sapiens, who is born alive at any stage of development. As used in this section, the term born alive, with respect to a member of the species Homo sapiens, means the complete expulsion or extraction from his or her mother of that member at any stage of development, who after such expulsion or extraction breathes or has a beating heart, pulsation of the umbilical cord, or definite movement of voluntary muscles, regardless of whether the umbilical cord has been cut, and regardless of whether the expulsion or extraction occurs as a result of natural or induced labor, cesarean section, or induced abortion. Nothing in this section shall be construed to affirm, deny, expand, or contract any legal status or legal right applicable to any member of the species Homo sapiens at any point prior to being, quote, born alive, as defined in this section. It's important to note, under Ballantyne's Law Dictionary, a human is classified as a monster, and a monster hath no inheritable blood. It was a term created to prevent the passing of inheritance or sovereignty in law. It's also important to note that human, especially under articles like Encyclopedia Britannica, reference a hominin species, one that is under the order of primates. For those familiar with the book of Jasher, when the Most High turned a third of the men working on the Tower of Babel to apes and elephants, it becomes strikingly clear that not everyone is completely and genuinely sons of Adam, as it differentiates between humans and human beings versus man, or the son of Adam, sons of Adam, descendants, and heirs. So, if you have your name change decree or order, showing your name is not spelled in all capital letters, rather in proper case, what do you do then? Well, seeing as the name change is considered a bill of reviver, or the name correction, rather, then you are able to probate a will. In Texas, it's considered probating a will as a muniment of title more than 4 years after the death of the decedent. In other states, it's going to vary widely. You can file a will to do this. You can file other things to revoke presumptions of death. It just depends. Again, this is not legal advice. This is not financial advice. This is not tax advice. Again, these are specialized processes that vary widely depending on your locale and jurisdiction. But this is something very possible. I've done it. I know other people that have done the same. And at this point, the courts have ruled and given me orders in favor, granting the estate to myself as executor. And as far as proving life, you have to pay attention to the rules of evidence. Now, something published on the public record, whether that be through the paper, whether that could be through other recorders of deeds, things like that. It depends on your locale and your jurisdiction to see who has the authority to record certain things like that. That's something that can be done. Now, with the use of any canceled registered mail number, i.e. like a poor man's copyright, to cancel out the registered mail number, sending registered mail to yourself to prove a claim. That's the only way that you can cancel out a registered mail number is if you're both the sender and the recipient, as you have the rights to granting the item itself and receiving it as a recipient. So the witness in this particular form is the capitis diminutio minima, the proper case estates, first, middle, last, first, middle, initial, last, and first and last. And the executor in capitis diminutio nolo is seen as shown. Again, review your local jurisdiction to ensure compliance with all the different requirements. And don't forget to pay and apply the stamp duties and cancel them accordingly. And testimony thereof, first-hand testimony as you are living, and any living being has the right to self-determination, to determine who and what they are, because you're bound by your own word. And this particular document can be seen in the To Be Fruitful Training Group's private library. And any applicable stamp duties must be canceled and applied correctly in accordance with British and American law. So let's just say that you've won in the secular courts or the courts temporal. Now, what am I referencing about that? Well, you have to go back farther to understand what actually happened. So here we have the ordinance of William I, William the Conqueror, separating the spiritual and temporal courts. And it states, William, by the grace of God, King of the English, to R. Baynard and G. de Magnavia and P. de Valois, forgive me, I don't speak French, and to my other faithful ones of Essex and of Hertfordshire and of Middlesex, greeting. Know all of you and my there faithful ones who remain in England, that in a common council, and by the advice of the archbishops and bishops and abbots, and of all the princes of my kingdom, I have decided that the episcopal laws, which up to my rime in the kingdom of the English, have not been, up to my rim in the kingdom of the English, have not been right, or, quote, according to the precepts of the holy canons, shall be amended. Wherefore I command, and by royal authority decree, that no bishop or archdeacon shall any longer hold in the 100 court pleas pertaining to the episcopal laws, nor shall they bring before the judgment of secular men any case which pertains to the rule of souls. But whoever shall be summoned according to the episcopal laws, in any case or for any fault, shall come to the place which the bishop shall choose, or name for this purpose, and shall there answer in his case or for his fault, and shall perform his law before God and his bishop, not according to the 100 court, but according to the canons and the episcopal laws. But if any one, elated by pride, shall scorn or be unwilling to come before the judgment seat of the bishop, he shall be summoned once, and a second time, and a third time. And if not even then he may come to make amends, he shall be excommunicated. And if it be needful to give effect to this, the power and justice of the king or the sheriff shall be called in, but he who was summoned before the judgment seat of the bishop shall for each summons pay the episcopal fine. This also I forbid, and by my authority interdict, that any sheriff or provost, or minister of the king, or any layman concern himself in the matters of laws which pertain to the bishop, nor shall any layman summon another man to judgment apart from the jurisdiction of the bishop. But judgment shall be passed in no place except within the episcopal see, or in such place as the bishop shall fix upon for this purpose. So it's important to note that the bishop is the one overseeing a lot of certain things with regards to the rule of souls. And it's also something to note that with the 3 times it being summoned relates to administrative processes regarding the initial notice, the notice of fault and opportunity to cure, and the notice of default and dishonor. And another example of this is the John Wick movies, where John Wick was excommunicado from the Continental and from that realm. And don't forget to do the executor document and the forgiveness document, as well as fee schedules. And depending on your situation, a warranty deed and a private foreign trust may still be required. It is something that most people realistically need, so something to bear in mind and consider. This is not intended to be comprehensive, and this does not constitute tax advice, financial advice, nor legal advice. This will require quite a bit of additional due diligence with regards to the other steps in far as procedure based on your locale and your jurisdiction, wherever you're located at. If you'd like assistance or guidance based on my experiences, again, this is not legal advice, you can book a consultation. I don't charge for the first 30 minutes just to find out a little bit more about what's going on and whether or not I'm able to assist. And then thereafter, I have a charge for my time. If you'd like to book a consultation, go over to my website, where you can find that in the description and most of my videos. And go ahead and fill out that contact form, and then I will get back to you as soon as I'm able to. If for some reason you don't receive a response within 2 to 3 days, go ahead and send an email to the email address listed on that page, and I will get back to you as soon as possible. If you'd like to get access to the documents and templates shown here in the video, any donations over $50 will receive a link to Be Fruitful Training Group's private library, where these documents and templates are provided as a courtesy. Again, thank you for all the positive feedback. Thank you for liking, commenting, and sharing. It goes a long way. I'm thankful and grateful for everyone that took the time to view this. And yeah, all praises and glory to the Most High. This is B with To Be Fruitful Training Group, and we'll see you on the next one. Thank you.